The Egyptian-European summit kicks off in Brussels. The European Union emphasizes readiness to cooperate with Egypt on all international issues. And North Sinai governor confirms that the Egyptian side of the Rafah border crossing has always remained open.
And then, of course, we have the host tonight, and I just want to thank you very much. It was a reason we chose Egypt, because you were very helpful, and very, very helpful. Everybody wanted to have this, but we really thought it was appropriate, and you are a great leader. And he's a fantastic man and a fantastic general, by the way. But he's a great president, and I want to thank Egypt and all of your representatives for treating us all so well. Thank you very much.
You're watching Q News. It's 4 p.m. Cairo local time. I'm Hani Saif, and these are the news today. The Egyptian-European summit kicks off in Brussels, with the Egyptian President Abdel Fattah el-Sisi and several EU leaders in attendance. President el-Sisi arrived in the Belgian capital yesterday for the summit, which also includes a major economic forum highlighting investment opportunities in Egypt and attracting participation from leading European companies. According to the Egyptian presidency, the visit aims to strengthen political cooperation frameworks and deepen coordination with the European side on shared regional and international issues. EU Foreign Policy Chief Kaja Kallas has affirmed that the bloc is working closely with Egypt to strengthen their strategic partnership and expand investment opportunities. That comes as the Egyptian-European summit kicks off in Brussels, with the participation of the Egyptian President Abdel Fattah el-Sisi and several European Union leaders. During her meeting with President el-Sisi on the sidelines of the summit, Kallas emphasized the EU's readiness to cooperate with Egypt on all international issues, particularly the crisis in Ukraine, the Middle East, Sudan, and Libya. Egyptian Prime Minister Mustafa Madbouli has said that the Egypt-EU summit reflects the European Union's strong confidence in Egypt's pivotal regional role. He noted that the summit will witness the signing of several key understandings between Egypt's President Abdel Fattah el-Sisi and European leaders, marking a new phase in bilateral cooperation. Madbouli added that the event will also see the announcement of concrete steps to implement the Egypt-EU strategic partnership. Ladies and gentlemen, we now go live to a broadcast from the Netherlands, where the International Court of Justice delivers its advisory opinion on the obligations of Israel regarding humanitarian access to Gaza. Let's watch.
And if so, whether there is any reason why it should, in the exercise of its discretion, decline to answer the request. The Court knows that by virtue of Article 96, Paragraph 1 of the Charter, the General Assembly may request the International Court of Justice to give an advisory opinion on any legal question. The Court considers that the question submitted to it is a legal question within the meaning of Article 96 of the Charter and Article 65 of the statute. The Court concludes that it has jurisdiction to render an advisory opinion as requested by the General Assembly. Turning to discretion, the Court recalls that only compelling reasons may lead it to refuse to give its opinion in response to a request falling within its jurisdiction. The Court focuses on arguments that were either not addressed in its advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem, to which I shall refer as the 2024 advisory opinion, or that arise from the distinct legal and factual context of the present proceedings. The Court first considers the argument that the question put to it is premised on allegations that are currently under consideration in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel, and that giving the advisory opinion might prejudge elements relevant to that case. The Court does not find this argument convincing, as there is a clear difference between the respective subject matters of the two proceedings. In the present advisory case, the Court's mandate is limited to the identification of Israel's obligations as an occupying power and as a member of the United Nations in relation to the presence and activities of the United Nations in and in relation to the occupied Palestinian territory. By contrast, the contentious case between South Africa and Israel concerns the question whether Israel has violated its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, to which I shall refer as the Genocide Convention. The distinction between the two proceedings is unaffected by the fact that the Court's orders indicating provisional measures in the contentious case direct Israel inter alia to ensure the provision of basic services and humanitarian assistance to the population in the Gaza Strip. The measures indicated seek to preserve certain rights that the Court found to be plausible under the Genocide Convention. Although the same conduct may be required of a state under different legal rules, and the same conduct may simultaneously breach multiple obligations, a determination made by the Court in the context of one obligation does not necessarily prejudge the question of compliance with a different obligation. Here, the facts that are relevant to a potential finding of a violation of obligations under the Genocide Convention are sufficiently distinct from the facts that are relevant to the determination of Israel's obligations as an occupying power and as a member of the United Nations in the present context. There are, however, factual and legal matters that may be relevant both in the present advisory proceedings and in contentious proceedings. In this respect, the Court recalls that the parties to pending contentious proceedings will have the opportunity to present evidence and arguments on questions of fact and law on the basis of which the Court will decide in those proceedings. The Court then turns to the argument that the question put to it has already been largely addressed in its previous advisory opinions on the legal consequences of the construction of a wall in the occupied Palestinian territory and on the 2024 advisory opinion. The Court considers that the current request differs from the earlier ones and concerns a question that was not addressed in the previous advisory opinions. First, the present request pertains to a specific issue that had not emerged at the time of the earlier advisory opinions. As recounted in the preamble of Resolution 79/232, the General Assembly's request was approved following Israel's adoption of legislation on 28 October 2024, curtailing the operations of the United Nations Relief and Works Agency for Palestine Refugees in the Near East, UNRWA. Second, the 2024 advisory opinion was limited ratione temporis to policies and practices taking place before 7 October 2023. By contrast, the present request concerns conduct taking place after that date. The Court then examined the argument that the request would require it to undertake significant factual investigations and make findings on disputed and evolving matters which cannot properly be pursued in the framework of advisory proceedings. The Court notes that the case file contains ample documentation concerning the relevant facts. In the present case, the Court considers that the information available enables it to decide legal questions in a manner consistent with its judicial function. Finally, the Court rejects the argument that the request abuses and weaponizes the international judicial process. Even if allegation of abuse of process could be advanced in the context of advisory proceedings, the Court does not consider that there is any basis for such a finding in the present case. The Court concludes that there are no compelling reasons for it to decline to give the opinion requested by the General Assembly. The Court then outlines the general context of the opinion. It recalls the historical background of the situation with regard to the occupied Palestinian territory. The Court next discusses how the United Nations, and in particular the General Assembly, became involved in the provision of humanitarian assistance to Palestine refugees, both Arab and Jewish. It notes inter alia the establishment of UNRWA in 1949 and the commencement of its operations in 1950. On 14 June 1967, UNRWA and Israel concluded a provisional agreement concerning assistance to Palestine refugees in the occupied Palestinian territory, to which I shall refer as the 1967 agreement. The 1967 agreement provided that UNRWA would continue its assistance to Palestine refugees with the full cooperation of Israeli authorities in the West Bank and Gaza Strip areas, and that Israel would facilitate the task of UNRWA to the best of its ability, listing a number of commitments taken on by Israel. According to the United Nations, over its 75-year history, UNRWA has become a pivotal agency for relief and assistance to Palestine refugees in the occupied Palestinian territory. Its mandate has been extended pursuant to successive General Assembly resolutions, the most recent of which extended the mandate of UNRWA until 30 June 2026. The Court observes that other UN agencies, United Nations agencies and bodies, specialized agencies, international organizations, and third states also provided assistance in or in relation to the occupied Palestinian territory. The court then recalls that on 7 October 2023, Hamas and other armed groups present in the Gaza Strip carried out attacks in Israel, killing more than 1,200 people, injuring thousands, and abducting 251, some of whom continued to be held hostage for more than 2 years. Following these attacks, Israel launched a large-scale military operation in the Gaza Strip by land, air, and sea, which has caused massive casualties, including the deaths of tens of thousands of civilians, a large number of whom were women and children, extensive destruction of civilian infrastructure, and the repeated displacement of the overwhelming majority of the civilian population in the Gaza Strip. In the course of its military campaign, Israel has substantially restricted and for significant periods of time, including between 2 March and 18 May 2025, completely prevented the entry of aid into the Gaza Strip and its distribution to the Palestinian population, with catastrophic consequences for this population. The United Nations reported numerous attacks on school buildings and healthcare facilities in the Gaza Strip, operated by the United Nations and others, including school buildings that have been directly hit. The Secretary General of the United Nations has stated that between 7 October 2023 and 20 August 2025, at least 531 aid workers, including 366 United Nations personnel, 360 of whom were employed by UNRWA, have been killed in the Gaza Strip. In January 2024, Israeli authorities alleged that a number of UNRWA employees had been involved in the 7 October 2023 attacks, that UNRWA premises have been appropriated by Hamas for military purposes, and that UNRWA had long lost its neutrality. The United Nations immediately took steps to investigate these allegations. In this connection, the court discusses the investigations conducted by the Office of Internal Oversight Services of the United Nations, to which I shall refer as the OIOS, and the investigation by an independent panel set up to assess whether UNRWA was taking all reasonable steps to ensure its neutrality. Notwithstanding these steps, Israel has maintained its complaints about UNRWA. On 28 October 2024, the Parliament of Israel, the Knesset, adopted 2 laws entitled the Law to Cease UNRWA Operations and the Law to Cease UNRWA Operations in the Territory of the State of Israel, respectively. The court notes that the second of these laws purports to apply to East Jerusalem. By a letter dated 3 November 2024, the Ministry of Foreign Affairs of Israel informed the President of the General Assembly that Israel had withdrawn its request to UNRWA to provide humanitarian assistance to Palestinians pursuant to the 1967 agreement. According to Israel, that agreement was terminated. By a letter dated 24 January 2025, Israel informed the Secretary General that UNRWA had to cease its operations in East Jerusalem and evacuate its premises there no later than 30 January 2025. The two laws on UNRWA, adopted by Knesset, entered into force on that date. The court recalls that Israel did not allow any aid to reach the Gaza Strip from 2 March until 18 May 2025. Since 19 May 2025, the Israeli authorities have allowed the United Nations to resume the delivery of limited aid into the Gaza Strip. The United Nations and the Observer State of Palestine have, however, alleged that Israel has continued to impose substantial restrictions on the entry and distribution of aid and commercial goods into the Gaza Strip. They maintain that, as of the end of August 2025, the humanitarian situation in the Gaza Strip had become catastrophic, with evidence of famine, mass displacement, extreme levels of deprivation, and a continued increase in civilian casualties, including children. On 27 May 2025, Israel launched a new aid distribution system through a private foundation called the Gaza Humanitarian Foundation and a private security firm, with only a few distribution points, mainly in southern Gaza. Israel alleged that this new system was required to prevent diversion of aid by Hamas. The United Nations, other international organizations, and humanitarian non-governmental organizations considered that this new system did not align with humanitarian principles, did not meet people's needs, and put people at risk, and they refused to collaborate with it. Having given an overview of the humanitarian relief situation in the Gaza Strip, the court then turns to the scope and meaning of the question posed by the General Assembly. The court observes that the question concerns the identification of the obligation of Israel. The General Assembly did not ask the court to determine the legal consequences of any breach of these obligations. For this reason, the court does not consider that it is called upon to determine whether Israel has violated its legal obligations or to address the legal consequences of Israel's conduct, including under the law of state responsibility. The court explains that identification of Israel's legal obligations cannot be undertaken in purely abstract terms and requires taking the particular situation under the request into account. Thus, the court states that it will base its assessment on the factual situation and identify Israel's obligations with the degree of specificity it considers warranted to fulfill its judicial function. Turning to the territorial scope of the question, the court notes that the question covers Israel's obligations in relation to United Nations entities, other international organizations, and third states in and in relation to the occupied Palestinian territory. Thus, in addition to Israel's obligations in the occupied Palestinian territory, the request also requires consideration of Israeli activities undertaken in Israel territory or elsewhere to the extent that they concern the presence and activities of United Nations entities, other international organizations, and third states in relation to the occupied Palestinian territory. The court further observes that while the question encompasses Israel's obligations in the occupied Palestinian territory as a whole, due to the specific reference in the request to urgently needed supplies essential to the survival of the Palestinian civilian population, it will pay particular attention to Israel's obligations in the Gaza Strip. In terms of its temporal scope, the General Assembly's request does not include any limitations. Moreover, the Court is aware that the situation in the occupied Palestinian territory is evolving rapidly. The Court indicates that it bases its legal analysis primarily on the facts as they stood at the closure of the oral proceedings on 2 May 2025, as well as on the participants' replies to the questions posed during the oral proceedings, which were received on 7 May 2025. Additionally, the Court takes into account subsequent developments based upon the information presented to the Court at its request by the United Nations, Israel, and the Observer State of Palestine, which was received by 8 September 2025. The Court observes that the request concerns two main categories of obligations. Accordingly, the Court will first consider the obligation of Israel as an occupying power. Then the Court will turn to the obligation of Israel as a member of the United Nations. The Court recalls that an occupying power has a general obligation to administer the territory for the benefit of the local population. Israel's particular obligations as an occupying power in relation to the presence and activities of the United Nations, other international organizations, and third states are governed by international humanitarian law, in particular the law of occupation, and by international human rights law. With regard to international humanitarian law, the Court notes that Israel's relevant obligations follow from the Geneva Convention relative to the protection of civilian persons in time of war of 12 August 1949, to which I shall refer as the Fourth Geneva Convention, to which Israel is a party. As confirmed in the Court's jurisprudence, the Fourth Geneva Convention is applicable in the occupied Palestinian territory. Moreover, Israel has obligations under customary international law, notably as reflected in the regulations respecting the laws and customs of war on land annexed to the Fourth Hague Convention of 18 October 1907, and in certain provision of the Protocol Additional to the Geneva Conventions of 12 August 1949, and relating to the protection of victims of international armed conflicts, to which I shall refer as the Additional Protocol 1. The Court emphasizes the fundamental importance of the principle of distinction under international humanitarian law. As a corollary to this principle, the Court recalls the principle of proportionality and also refers to the principle of precaution. The Court then discusses Israel's status as an occupying power in the Gaza Strip. The Court recalls that it found in the 2024 advisory opinion that after the withdrawal of its military presence in 2005, Israel remained capable of exercising and continued to exercise certain key elements of authority over the Gaza Strip, and that Israel's obligations under the law of occupation have remained commensurate with the degree of its effective control over the Gaza Strip. These findings were based on the control exercised by Israel over the Gaza Strip prior to 7 October 2023, including control of the land, sea, and air borders, restrictions on movement of people and goods, collection of import and export taxes, and military control over the buffer zone. Since that date, Israel's effective control over the Gaza Strip has increased significantly, as evidenced inter alia by Israel's increased military control in large portions of the territory and Israel's blocking of aid between 2 March and 18 May 2025, which prevented all humanitarian aid from entering into the Gaza Strip. Therefore, the Court finds that Israel's obligation under the law of occupation have also increased significantly, commensurate with the increase in its effective control over the territory. Those obligations include the obligations under the law of occupation considered hereinafter by the Court. The Court observes that the fact that hostilities are ongoing does not necessarily preclude the simultaneous application of the law of occupation. When hostilities take place in an occupied territory, the law of occupation applies alongside other rules of international humanitarian law relating to the conduct of hostilities, and the occupying power must comply with both sets of rules. However, the intensity of the hostilities could affect the implementation of certain obligations under the law of occupation, and therefore the particular conduct required of the occupying power. The Court next considers the relevance of Israel's security concerns, of which it is conscious. The Court observes that while certain provisions of the Fourth Geneva Convention and other rules of customary international law allow the occupying power to take consideration of security or military necessity into account, the protection of security interests is not a freestanding exception permitting a state to depart from the otherwise applicable rules of international humanitarian law. Any limitations on Israel's obligations under international humanitarian law based on its security concerns must be grounded in a specific rule. The Court underscores that reliance upon such concerns must be exercised in accordance with the principle of good faith. Further, the Court emphasizes that when states take measures to combat terrorism, they must comply with their obligations under international law, in particular, their obligation to respect international humanitarian law and international human rights law. Turning to the relevant framework under international humanitarian law, the Court observes that customary international law imposes a duty on all parties to an armed conflict to allow and facilitate rapid and unimpeded passage of humanitarian relief for civilians in need, subject to a limited right of control. Such relief actions must be impartial in character and conducted in a non-discriminatory manner. More specific obligations apply in the case of occupation. Articles 55 and 56 of the Fourth Geneva Convention obligate an occupying power to ensure that the population of the occupied territory is supplied with the essentials of daily life, including food, water, shelter, medical supplies, and medical care. Article 59 imposes additional obligations that depend on the population being inadequately supplied. Recalling the particular context of this case, the court begins its analysis with Israel's obligations under Article 59 of the Convention. The court emphasizes that as the occupying power, Israel's obligation under the first paragraph of Article 59 to agree to and facilitate relief schemes if the local population is inadequately supplied is unconditional. Relief schemes under Article 59 may be undertaken either by states or by impartial humanitarian organizations. The provision thus places obligations upon Israel both in relation to third states and in relation to the United Nations and other humanitarian organizations. These organizations must qualify as impartial to come within the scope of Article 59. The fourth paragraph of Article 59 accords certain rights to a state granting free passage to consignments. These include, inter alia, the right to inspect consignments and the right to be reasonably satisfied that these consignments are to be used for the relief of the deprived population. However, no state may exercise these rights to impede the delivery of relief consignments in a manner that undermines the performance of its obligations as set out in Article 59. An occupying power's obligation to agree to and facilitate the entry of humanitarian relief into an occupied territory under Article 59 does not displace its basic obligations to ensure the availability of food and medical supplies essential to the survival of the local population. Other provisions of the Fourth Geneva Convention confirm that aid can be impeded only temporarily and for narrowly circumscribed reasons. For example, the second sentence of Article 60 provides that, and I quote, "The occupying power shall in no way whatsoever divert relief consignments from the purpose for which they are intended, except in case of urgent necessity, in the interest of the population of the occupied territory."
Ladies and gentlemen, that was a live broadcast from The Hague, where a session of the International Court of Justice was convened to issue an advisory opinion on Israel's obligations regarding humanitarian aid to Gaza. The president of the court read out the advisory opinion. The judge at the International Court of Justice stated that Israel continues to violate agreements related to the delivery of humanitarian aid to Palestinians. The judge rejected Israel's claims in the cases currently before the court, emphasizing that Israel has obstructed relief organizations from operating in Gaza. He added that Israel has committed acts amounting to genocide in the enclave and must immediately allow the entry of humanitarian assistance to alleviate the suffering of civilians. He said the United Nations had documented Israeli attacks on its staff in Gaza. He added that Israel had suspended the operations of UNRWA in the occupied territories and imposed severe restrictions on the entry of humanitarian aid into Gaza. The judge stressed that the court's evaluation of the ongoing cases would rely on the facts observed on the ground. Back to our news, and North Sinai Governor Khalid Megawer has confirmed that the Rafah border crossing has remained open from the Egyptian side since October 7th of 2023. That came as a Danish parliamentary delegation inspected the Rafah border crossing from the Egyptian side. Megawer stated that Egypt continues to provide medical care for injured Palestinians through 3 dedicated medical lines, and that efforts are underway to expand humanitarian assistance, with over 70% of aid to Gaza sent from North Sinai. The North Sinai governor emphasized Egypt's vital role in implementing U.S. President Donald Trump's peace plan. Megawer also called for active participation in Gaza's reconstruction conference and reaffirmed commitment to the two-state solution based on UN resolutions. These were the news that we have for now, but before we wrap up, here's a recap of the top stories making the headlines this hour. The Egyptian-European summit kicks off in Brussels. The European Union emphasizes readiness to cooperate with Egypt on all international issues. And North Sinai governor confirms that the Egyptian side of the Rafah border crossing has always remained open. That brings us to the end of our news bulletin for now, but for more stories and live updates, follow Q News on YouTube, Facebook, X, Instagram and TikTok at QNewsEGY. From all of us here, thank you for watching and stay tuned for more coming up here on Q News.